This is Duke University.
I'm Samantha Grill, Editor-in-Chief of the Duke Journal of Gender Law and Policy, and I wanted to welcome you all to our final day of our Spring 2012 Symposium. This year we've been focusing on criminal law and gender, and our final presentation is by our 3L Special Projects Editor. We're publishing her note this spring on the parental rights of rapists. So we have Ms. Bitar here today, and we also have Professor Bradley, who supervised her note, here as well to help answer questions at the end. So with that, I would like to welcome Ms. Bitar.
Thank you, Sam. Can everyone hear me? Okay. To Sam and to the members of the Journal, I just want to say thank you for this opportunity to speak about something that I've spent a lot of time with and that I think is a really important issue that a lot of people don't know about. And I want to say a special thank you to the staff editors and the executive editor who are working on my note. I know how much work that is. I know how busy you are, and I really appreciate it. I want to say a special thank you to my mom. My mom, last night she surprised me. She drove in, and I really appreciate that. So that was really nice. And she walked in the house and started cooking. So after driving for 8 hours, so that was a really nice surprise. I also want to say a special thank you to Professor Becton, who's here today. Professor Becton, I took his rhetoric class, and I just have to say that, I mean, he inspired me in a unique way, and I just will never forget that class, so thank you. And in addition, I want to recognize Professor Brenda Berlin is here today, and of course, Professor Bradley. I worked at the Children's Law Clinic after my 1L year, and it was such a great experience. She not only is a good professor, but she's a wonderful person, so thanks for being here. And of course, Professor Bradley. It was really her family law class that made me want to research something in family law. And in addition to that, she was so willing to supervise this note, even though I think the topic is kind of interesting. I think she kind of wondered where I came up with it, but she was just so willing to help me, and she really pushed me to grapple with these issues and I think write a better note. So, and she's also agreed to be here today to answer questions that you may have that are more specific to family law. So thank you for being here today, Professor Bradley. Okay. And thank you everyone else for coming. I appreciate it. I'll just let everyone kind of get seated. There's 3 seats up here. Yeah. So I want to start by telling you about a recent event in Afghanistan. In Afghanistan, a 19-year-old was raped. She reported the rape to the authorities, and as a result, she was imprisoned for adultery. Now, at first, her sentence was set at 3 years, and then she was sentenced to 12 years in prison. Now, she had become pregnant as a result of this rape, and she gave birth to her child while she was in prison. Now, at this time, there was a public campaign that was demanding that this woman be pardoned. And as a result of this campaign, a judge finally agreed to pardon her. But there was a catch. She would be pardoned if, and only if, she agreed to marry the man who raped her and raise her child with him. Thankfully, we don't live in Afghanistan. We live in America. And in America, we recognize rape for the horrible crime that it is. In America, we protect women from this heinous act. And in America, we respect women, and we take their rights seriously. Or do we? Ladies and gentlemen, in the majority of states in this country, if a woman becomes pregnant as a result of rape and keeps her child, the rapist father has all of the same rights as does any other biological father. So in the majority of states in this country, if a woman is raped and keeps her child, she faces the real risk that she will have to raise her child with the man who raped her. She may be forced to share custody with this man. She may be forced to consult him before she makes decisions concerning the child. She may be forced to tell him every time she brings a child to see a doctor or a dentist. She may even be prevented from moving so that her child can remain close to this man. A woman in North Carolina relayed the following story. She said, "I was raped in North Carolina. The rapist won joint custody. Torment does not come close to describe what I live. The courts have not only tied and bound me to a rapist, but also the innocent child that was conceived by violence. The rapist's violence has earned him even more control over my life." How can this be in our country? To understand this problem and how it can be addressed, it's first important to understand parental rights. In America, parental rights are fundamental, and so courts are very hesitant to strip parents of these rights. Now, I know what you're thinking. Even if these rights are fundamental, raping someone seems to be a legitimate reason to take these rights away from parents. But in practice, because parental rights are so strong, in circumstances such as these, courts are just not willing to do it in most situations unless there's some form of legislation in place. For instance, in a case out of Alaska, there was substantial evidence that a woman was raped and that a child was a result of that rape. Nonetheless, the courts would not terminate the father's parental rights. The court said, "Termination of parental rights will not be accomplished absent some statutorily mandated procedure." So in order for the parental rights of rapists to be limited, there needs to be some form of legislation. This is not something that we can leave in the court's discretions to determine, because if we do, it's likely that they will allow that father to have those rights. Now, states do recognize that some form of legislation is necessary. And we know this because 30 states have enacted legislation that limits the parental rights of rapists in some form. However, even the states that have enacted legislation do not provide real protection to rape victims. And in the majority of these states, if a woman keeps her child, she is provided absolutely no protection. So I want to discuss the legislation that does exist, and I want to talk about three main reasons that this legislation does not provide real protection to rape victims. First, 12 of the 30 states that have enacted legislation limit their protection to adoption. So that means a woman may place her child for adoption without the consent of the biological father if the child was conceived as a result of rape. Now, it is important that victims be able to do this. In fact, rapists have even used their consent to adoption as a means of blackmailing their victims. For instance, in North Carolina, legislation to limit the parental rights of rapists was enacted when people became aware of an incident where an alleged rapist who was waiting trial told his victim he would not consent to the adoption unless she agreed not to testify against him. So, But as important as this type of legislation is, if a woman keeps her child in these states, she is provided absolutely no protection. So if the woman places her child for adoption, she's protected. If she keeps it, she's not. Now, 11 states do allow for the termination of all of a rapist's father's parental rights. So this means custody, visitation, and adoption. But it's not so simple. And this brings me to the second reason why existing legislation does not provide real protection to rape victims. 6 of these 11 states allow for the termination of parental rights if, and only if, the rapist has been convicted of rape. Now, this may sound reasonable. How else will we know if the woman is telling the truth? And how else can we protect innocent fathers? But the reality is that the majority of rapists are never caught, tried, or convicted. Rape is vastly underreported. A National Institute of Justice report found that only 19.1% of women raped since their 18th birthday even reported the crime. And only a small portion of those that are reported actually result in a criminal prosecution. And of those that are prosecuted, only a small portion result in a conviction. So, when legislation requires a conviction, it provides no protection to the majority of rape victims. Now, there are 5 states that do not require a conviction for the termination of all of a rapist's parental rights. For example, in Pennsylvania, if a victim proves by clear and convincing evidence that she has been raped and that a child is the result of that rape, a judge may terminate the father's parental rights. However, a judge does not have to. So even after a woman proves by clear and convincing evidence that she was raped and that a child resulted from that rape, the judge can still allow the father to have parental rights. This is problematic, and it's the third reason why existing legislation does not provide real protection to rape victims. To illustrate this, I want to tell you a story that comes out of Pennsylvania. In Pennsylvania in 2009, a couple became foster parents to a 3-year-old boy. This child was conceived as a result of rape, and his mother had become too overwhelmed to care for him. She was suffering immensely from the trauma of the attack. So, at 3 years old, this child was not potty trained and he was not talking. The foster parents had him for 2 years, and within those 2 years, he became potty trained, he started talking, and he was in school. And it was at this point that the couple decided to adopt him. Now, at this time, his biological father was awaiting trial for his 5th Megan's Law violation, and he was living in the basement of someone's home. Now, not only did this father refuse to consent to the adoption, but he requested custody, and the judge granted it. It was this event in Pennsylvania that spurred the introduction of a bill that would require judges to terminate a rapist's father's parental rights if the victim met her burden of clear and convincing evidence. Now, I don't know if that bill has been passed yet. I'm not aware that it has. So, the problem that we're facing first is just a lack of legislation. Only 30 states have any legislation at all. So in the other states, there's not even a recognition that if a woman is raped and becomes pregnant, that rapist does not have parental rights to that child. The second problem is that the legislation that exists does not provide true protection to rape victims. Now, you may be thinking, do we really need legislation, and how good does it really have to be? Because how much of a problem is this anyway? You might be asking, why would a stranger want parental rights over his victim's child? I mean, how would he even know that she had become pregnant? The fact is that most rapes are not stranger rapes. Stranger rapes account for only 10% of all rapes. A victim usually knows her attacker and has ongoing social and familial relations with him. He is a family friend. He is a coworker. He is a relative. He is a boyfriend, or he is a husband. And him having custody or visitation or blocking an adoption is just another way that he can assert control over his victim. Also, women do become pregnant as a result of rape. A recent study found that there are 25,000 rape-related pregnancies a year in the United States. And a study of 34 rape-related cases rape-related pregnancies found that 32.2% did keep their child. But moreover, consider this. If a woman becomes pregnant as a result of rape, absent legislation that protects her, she is put in the following position. She can either place her child for adoption, or she can either terminate her pregnancy, she can place her child for adoption, or she can keep her child and take the real risk that a rapist will assert his parental rights and that she will have to raise her child with the man who raped her. So if a woman keeps her child, what can she do to ensure that she will not have to raise her child with the man who raped her? Even if she reports the rape, it's not her who decides that there's going to be a criminal prosecution. It's the DA. And the DA can even accept a plea. So even if she reports it, he may not be convicted. He may not end up in jail. And in most states, even if a woman is convicted, even if a man is convicted of rape, it doesn't terminate his parental rights anyway. So no matter what a woman does to try to protect against the possibility that she will have to raise her child with the man who raped her, the only way she can really protect herself is to have an abortion. We don't force women to have abortions in this country, and we should not be putting them in a position where that is their only legitimate option to protect themselves. Women need legislation to protect them from rapists having parental rights. And as a society, we should have such legislation. So first, states need to enact legislation. But the question then becomes, what should this legislation look like so that it provides true protection to rape victims? Now, I propose that to provide true protection, legislation must, first, allow for the termination of all of a rapist's parental rights. Second, it must not require a conviction. Third, it must cabin the discretion of judges. And it must do one more thing. It must have something in place so that it protects innocent fathers from being stripped of their parental rights. And it's this last piece, it's protecting innocent fathers, that has prevented at least some legislation from being passed. In Maryland, a bill was proposed that would terminate all of a rapist's parental rights, and this idea of it not protecting innocent fathers seems to be one of the reasons that it wasn't passed. I believe there is a way to devise legislation so that it can protect women and also protect innocent fathers. And in my paper, I propose such legislation, and I'll give you a summary of it. So initially, I believe that the legislation needs to be split up. So part of it covers when there's a conviction, and part of it covers when there's not a conviction. Currently, there is no legislation that splits these two things up and treats them differently. So first, the first part of the legislation I would propose is that if a rapist is convicted, if there is a conviction, and a woman proves by a preponderance of the evidence that the child was a result of that act, the court must terminate all of the father's parental rights. And secondly, I propose that if there's not a conviction, if a woman proves by clear and convincing evidence that she was raped and that a child was the result of that rape, a court must terminate all of the father's parental rights. So this legislation, it allows for the termination of all parental rights. It does not require a conviction, but if there is a conviction, it lessens the victim's burden of proof. It cabins the discretion of judges, and it does protect the accused, because a burden of clear and convincing evidence is a high burden. Additionally, it doesn't automatically terminate a father's parental rights. Even if he is convicted of rape, the victim still has a burden that she has to meet. And in addition, this legislation that I propose is limited to first and second degree rape. Now, some of the legislation that's on the books now is just rape. So that's going to include statutory rape. And I propose that this legislation provides more protection to the man because it does not include statutory rape. There is a risk with this legislation that a woman could lie and an innocent father could lose his parental rights. However, given the burden that a woman must meet, such an occurrence will likely be rare, especially because absent a conviction, usually there's not much evidence for her to work with. And also, rape is notoriously hard to prove. But moreover, women are in a unique position when it comes to pregnancy, childbirth, and child-rearing. In these areas, laws should be structured to take the unique circumstances of women into account. In the realm of rape-related pregnancies, women are the ones who have to bear the pregnancy, or the ones who have to have an abortion. They are also the ones who may form a biological connection with their unborn and yet place their child for adoption. These are burdens only women bear. Women should never feel forced to have an abortion or feel forced to place their child for an adoption or forced to raise their child with the man who raped them. The idea of such things is appalling. If legislation is not enacted to protect women, they could be forced to do these things. Our system does not function to perfection, not in the realm of criminal law, family law, or any other type of law. There is always a possibility that the innocent will be punished and that the guilty could go free. And while there may not be legislation that will ensure that an innocent father never loses his parental rights, there also will never be legislation that can ensure that a woman doesn't have to raise her child with the man who raped her. We as a society live with this imperfection, and it should not stop us from doing the best that we can. Further, having legislation in place to terminate the parental rights of rapists is a recognition by society that we support a woman's right to choose to keep her child, even if it is conceived by rape. And moreover, that we recognize rape for the heinous crime that it is, and that if it happens to a woman, we will do what we can to protect her from further torment at the hands of her attacker. I believe that such legislation is possible, and while it may not be perfect, the proposed legislation properly balances the interests of the accused while providing needed protection to rape victims. Thank you. So Professor Bradley is going to say a few words, and then we're going to open it up to questions.
And I am going to keep it to a few words because I know you're going to have lots of questions. And first of all, I want to say you did a terrific job presenting the paper. And I think the Afghanistan example is a really great one to start with, and because it's not so different from what you're talking about in the paper. We like to think we're a world away, and in fact we aren't. When she started, Kara said that she thought I probably wondered how she came up with this topic, and I think that's probably accurate. I probably did. And we had a lot of back and forth because I gave her a lot of pushback, particularly on the father's rights issues. And how do you protect that? Particularly looking as a family law instructor at examples in the past of where parents, for example, have made false allegations of child abuse in custody disputes and so forth. And I said, this is a potential area where the same thing could happen. But you came back with some good responses, and I particularly like the way you've worked with the statutes that are there to come up with one that is not perfect, but I think is really the best you can possibly do under the circumstances. One of the things, and I just want to spend a few minutes, one of the things I think this issue brings up is there's a lot of tensions going on here, okay, in terms of how we view rape, how we view relationships, how we view parenthood, and all those kinds of things. So one of the tensions, I think, is the fact that you noted that a lot of the rapes we're talking about are acquaintance rapes. And they're also fairly young women. So they may be in a position where they don't talk about the rape when it happens, they don't report it, they don't tell their parents if they're still living at home, so they don't establish early on who the father is, they don't have testing available to do that. By the time they may even be willing to acknowledge the pregnancy, they may be into their second trimester, so that if they even want to terminate the pregnancy, it's a much more complicated undertaking. Even though it's still legal, it's difficult. There are a few practitioners who will do it, and laws are becoming increasingly restrictive about late-stage abortions. So that's a tension. I think the fact that you're dealing with a lot of acquaintance rape means that we don't necessarily take it so seriously, okay? We now recognize that rape can occur within marriage, and every state has gotten rid of the marital rape exemption. But, you still have this sort of idea out there, well, didn't she agree? Or if she agreed in the past, did she agree this time? And so I think there's a lot of societal ambivalence about how much of this is really rape and how much of it is her just saying she doesn't want to have anything to do with the guy now, even if they actually had a relationship. And I think that's one of the things that makes it particularly hard to capture, because I don't think you're dealing so much with stranger rape situations here. I think one of the other issues that there's some serious tension on are the abortion rights issues, because one of the things we're seeing in the abortion rights discussion now were states that are imposing more restrictions. There have been statutes that have been proposed where there would not be an exception for rape. Okay? So if you have a situation where you're saying not to protect the life, the sanity of the mother, and no exception for rape, where you're therefore forcing the woman to carry a pregnancy to term, but you're not providing the protection for her to get out from under the relationship with the man who's caused the conception of the child, I think there's an imbalance there. And I think one of the issues that your article does is to bring that to light, to at least make us start looking at this in a more balanced way. I mean, I also think there's some prosecutorial issues here in terms of prosecutorial discretion, in terms of what do you do if you have a woman who is threatened? Do you drop the charges? Do we put something into the statutes that say if there's evidence that a man has attempted to blackmail the woman, is that itself evidence that should be used to terminate parental rights? But as long as a lot of control is staying out of the hands of the woman and in the hands of third parties, the man, the prosecutor, other witnesses, then it's a very difficult situation. And the other thing that occurred to me while I was listening to you, it concerns the way we deal with domestic violence now. So we've come a long way with domestic violence and with marital rape issues and things like that, and acquaintance rape and so forth. We now have much stronger domestic violence laws on the books than we used to. And we actually now have, in most custody statutes, domestic violence is something that the court can take into account in determining custody. So if you have a family that's splitting apart, and there's been an allegation of domestic violence by the husband against the wife, that can become a factor in then determining where the custody of the child goes. It won't necessarily go so far to terminate parental rights, but it certainly can determine custody. And if there's actually a conviction for murdering the wife, then that would actually terminate parental rights, okay? So it seems to me one of the things we also don't have yet is a full connection between all of these laws. We've got rape laws, we've got abortion laws, we have domestic violence laws, and maybe we need to find some ways to bring them together so that we can say, let's look at this situation as a domestic violence situation. And if we wouldn't award custody to a father who has abused his spouse, then we shouldn't be awarding custody to someone who has caused the violence that's led to the conception of the child. The other thing I would just say is, I mean, we are, you know, there is a balance for the father's rights, and there's been a huge push to acknowledge father's rights, which I think is generally good in the law. And particularly when you're talking about women being able to, outside of the rape context, unilaterally get an adoption put through without notifying the father, I think that's highly problematic from a parental standpoint in terms of rights. But we also ought to be talking about what's in the best interest of the child, because that's the standard we're looking at when we're determining custody and we're determining who's going to be responsible for the child. And that's something that I think we're not seeing come into play necessarily in these statutes yet.
Right. Yeah, they're not really talking about the child.
At all.
Well, actually, in Maryland, they did have an exception. This legislation didn't pass, but they said if the court finds by clear and convincing evidence it's in the best interest of the child, then they could exercise some discretion.
And see, I think if you then do that, then again you can begin to tie it back to normal custodial obligations. You can tie it back into normal standards for termination of parental rights, adoption statutes, and everything else. So I think one of the things is that right now you've got a lot of silos of laws that are dealing with this without saying, like, how does this policy relate to our adoption policy or our abortion policy or our domestic violence policy or anything else?
The struggle that I have with the children and the interest of the children is that, I mean, you don't want a child with someone who would rape someone. There's obviously a danger there. And the reason I kind of focused on the women was because I feel like the child doesn't know that man. Every time the child sees that man, he's not traumatized. And they've done studies where, like, rape victims have such a hard time moving on in general. When they have to see this person, I mean, see him, relate with him, talk with him, it's like, excuse me, they never recover. They never recover. And so I think there is definitely this tension between this best interest, like when you give the judges that discretion, it's almost like you feel like they need it, but then it's, on the one hand, it's very concerning for the women if the judges don't really understand. Like, this isn't a little thing that this woman has to see this man again, so.
I think that's a very important point, and I think it is a serious tension. I mean, I don't think that in that instance, I mean, I think it is in the best interest of the child to not be then dealing with the father because of what it's doing to the mother, but you sort of have to go through several steps to get there from here.
Yeah. Okay, I guess we'll open up for questions. Alyssa, you had your hand up as soon as I finished.
Two parents raising the child, having a mother and a father, or two, do you think that there's some kind of monetary thing going on here where the state would rather not pay for funds for the child and have the alleged rapist or the father of the child instead front child support? Do you think any of those considerations play in?
I'm not sure how much they play into the legislation. You'd probably be better able to answer that. I know in terms of, like, for instance, child support, one of the issues that rape victims face is that if they have the child, the state will look. Mm-hmm. And if they require state assistance, the state will then start looking for their father, which is a huge problem if they've been raped. But
and the state's required to do that by federal law. So there's, as part of the welfare reform back in the 80s and 90s, one of the things that the feds thought would help reduce welfare rolls was to collect more child support, right? So so states each have a structure now that's based on federal guidelines that says this is what we're going to do. And part of it is that if you are seeking benefits for children, you basically have to say what you can about who's the father, where are they, and so forth. Mm-hmm. Otherwise, you may not have the right to benefits. Now, there are some exceptions. Again, this ties back to domestic violence for, like if the woman's been abused and so forth. But again, I'm not sure there's a clear connection. And part of it then has to do with whether there have been charges brought, whether she's done something to assert the fact that this is a rape. Because there may be exceptions that would exist if she's made the claim already that this child was conceived through rape, that he did it, that this man assaulted her. But if those charges haven't been brought, then it makes it harder for her to establish that, and more likely that she's just, there's not any reason why she shouldn't have to come forward with the information about who he is and where he is.
Okay.
So I'm struggling a bit with the clear and convincing evidence standard
Mm-hmm.
in your proposal and in the existing legislation. It just seems that I think that you're absolutely right that it's vital to protect innocent fathers. But with the vast majority of rapes being acquaintance rapes and having so little evidence, and they so often come down to the he said, she said situation, I don't know that could ever meet that standard, and how many women are going to be left unprotected under that standard. And is there, I understand the struggle because it seems like a really difficult paradox, but
I think that's an excellent point. I kind of did question, is that too much? Is that too harsh? Is no woman going to be able to meet this? But reading through family law statutes in general, and I'm not sure, but that was the standard that seemed that they used in family law a lot when they were establishing, I don't know, in custody and visitation. That was kind of the common standard that I seemed to come across in the legislation that I was reading.
And first, I think that's true in some areas. And I think it's not a perfect standard. But I also think, and we talked about this a lot in the draft form, that preponderance would be too low because it makes it then too easy to become a he said, she said. Mm-hmm. This is I think in terms of evidence, what you might have is, did she bring charges? Did she file a police report at the time, even if a criminal case didn't follow? Did she go through a medical exam? Did she report to friends and family, he raped me or he attacked me? How did she look the day after it happened? Those kinds of things. And so I think it'll be easier to establish if she's taken some of those steps, which also, even if the prosecutor has not decided to pursue charges, or even if there's been a plea or whatever. I also think there ends up being more credibility if she's made those complaints, maybe even before she knows whether conception has occurred, okay? Certainly before the child is born. The further you get down the road, the harder it's going to be to establish that. So if she's gone through the pregnancy, had the child, and then we come to a point where she wants to seek adoption, and now she says, oh no, I was raped, I think that's a lot harder to establish, and I think it probably should be. So I think it's a tough standard, but I think that there's still some protections built in, and at the same time it may be protecting the father, at least on balance. Again, understanding there's no perfect standard for this.
And I just want to add to that too. So one of the things that Professor Bradley really pushed me to was you need to protect innocent fathers. And I think I kind of struggled with that a little bit because I, like you, thought, how are they going to meet this standard? I've been working in domestic violence court now this semester, and I really see what Professor Bradley is talking about. You really have to do something to protect innocent fathers. So you do need some sort of teeth to the standard so that she just cannot make up these charges. And I don't think clear and convincing is, I don't think it's impossible to meet, just because in domestic violence court, for instance, it is just there's not a ton of evidence to work with, but it's interesting how it can kind of become clear who's telling the truth and who isn't. It's interesting, not always, but it does happen. And I also think without this standard, legislation isn't going to be passed. I don't think states are going to pass it. And I think we're at the point right now where we need to get it. We need to get something on the books. We need to get something passed. And I also think, too, with domestic violence, as people have become more aware of the laws, they utilize them more. So I also think there needs to be more information put out there to women that this is available to them to use. And then I think they might, I think they might, if they knew it in advance, they might be able to meet that standard. Okay, Serena?
So I wonder if you thought about whether or not there should be different statutes or standards for minors who are in this situation. So you're thinking about acquaintance rape. You have a 14, 15, 16-year-old who's raped. They don't have their own health insurance. They may not go to the doctor, have a test done, have that evidence. They may not even tell their parents until they're showing. So you don't have some of these evidentiary protectors in place that you may have with an older woman who, you know, doesn't face the same emotional, psychological difficulties as a minor would in this situation. So how would you deal with that? And also, in the case that a 16-year-old rapist father may not care about his parental rights at that point, but years later he may care. And so how do you deal with individuals who the acquaintance rapist may say, I don't care, do whatever you want with the child. You know, 10 years later they decide, oh, I'm mature, I've settled now, I want to be in my child's life. How would you deal with that circumstance?
I mean, I haven't really thought about a lot of rapes occur to minors. It's extremely, extremely common. Should they have a different standard? I don't know. I mean, I think when I started writing this paper, I might have said yes. I think after being in domestic violence court for a few months, I'm just not sure. I mean, I think the standard, like I said, I think it does need to have something to it. And I think when you have a minor up on the stand testifying or saying these things happen, it's a little more, there's some believability issues there that you might not have with someone older. So I think they might be able to meet that standard. And in terms of getting custody down the road, yeah, that's absolutely, an issue, which is why I think that their rights should be terminated, all of their rights terminated, like, right away. I mean, if you find it out, they meet the standard, terminated.
I mean, I'd add that I agree. I think the credibility issues are going to be such that there's still going to be that protection, that clear and convincing is still going to work. On the custody down the road, I think that also then depends on what the mother has done at the time. So if she has sought to terminate his parental rights early on, then I think she's going to be able to do it. If she doesn't seek to do so, and 10 years later he says, I want to be in the kid's life, particularly if she's gone through the process of getting support or whatever, then I think it's a lot harder for her to establish. And I think it should be harder for her to establish. And at that point, if he hasn't had any contact 10 years down the road, how much of a relationship he can build with the child at that point, a different question too. So I guess maybe we're not worried enough about it, but I think it would shake out okay.
Rachel?
I had a question about the clear and convincing standard. If there's also a conviction to say, and this, by clear and convincing evidence, this child is a result of that conviction. I mean, I was just worried about situations where it's a boyfriend or a husband as the attacker, because you have this history. I mean, I can see a judge assuming that, you know, you've had sex in the past, and in the future, how are you going to pinpoint that one rape to the conception of this child when you have this time lapse? Have you come across anything?
So are you talking about, so if there is a conviction, I think it should be a preponderance of the evidence for proving that the child was the father, was the actual father's. If there isn't a conviction, then she would have the clear and convincing burden. And you're right. I mean, it's going to be harder with acquaintance rape. And unfortunately that's...
On the other hand, if you've convicted this man of raping this woman, okay, even if it's an acquaintance rape, okay, even if it wasn't this rape that caused the conception of the child, there's a good argument that if they've been in an ongoing relationship, I mean, the conception would have had to occur around the time, right? There's going to be only a certain range. So that there's still, I think, a good reason to say preponderance would be enough, and this would be enough to terminate his rights, for the same reason that you might do so with domestic violence statutes and other things.
So there doesn't have to be that sharp link between saying this date and this child was born on this, because I just see that as being sort of a difficult...
Oh, yeah.
I don't think
Not
you're going to
with-
be able to do
yeah,
that.
Not with a preponderance.
Okay.
I think it would. Yeah.
What would you do in a case where they go for a conviction charge and you don't meet the standard of proof? In that case, would you then allow another proceeding, a second proceeding to say, well, but maybe there's enough evidence for clear and convincing? And then how in cases like that, that just seems constitutionally a little sketchy, particularly given the nature of evidence in these cases is really if you believe one person or you believe that, I mean, it almost seems like two bites at the apple.
I think it's a good point, but I think that it would be, so you'd have one proceeding determine if he gets a criminal conviction for rape, which is a completely different, punishment. They're facing a loss of freedom, they're facing incarceration. And then I think you can also have a family law proceeding that would then determine custody, which is something, I think the two are considered separate.
Yeah. And the family law proceeding, or here the proceeding you're talking about to terminate rights, would be considered civil as opposed to criminal. So you don't have the same constitutional standards. And you can think about it in the context of the first OJ trial, okay, where he was acquitted, okay, of the murders, but then there was a civil action brought where there was only a preponderance standard. And so we see that happen a lot where, certainly it's easier to go to the civil action later if there's been a conviction, because then that's going to come right in. But even if there's been an acquittal or the charges have been dropped, there still might be enough to meet the standard. And in that case, it's only a preponderance standard. Right. Here with a clear and convincing, it is going to be different. So constitutionally, it's okay. The only thing I think that makes it a little difficult is you are talking about parental rights, which are treated as fundamentally constitutionally important, but it doesn't have the same criminal protections.
Well, and I guess the concern then is would that new standard become a standard in all constitutional cases related to parental rights, since we're lowering it in this case and making a clear cut between that and other things? And do you think that's a problem, or is that fine? Or
do I think it's okay that the standard be clear and convincing in a parental rights case?
I'm just thinking, would that become a new constitutional standard in general?
I don't see, as the law exists right now, I don't think that's a problem, okay? Because when you're looking at termination of parental rights, nothing is going to beyond a reasonable doubt standard. It's always something lower because it's not a criminal determination. So if there's an abuse and neglect proceeding where there's a determination to terminate parental rights because a parent has abused a child, it may go to clear and convincing. It may be preponderance. It depends on what the state statutory scheme is, but it doesn't have to rise to the level that it would have to for a criminal conviction. So I don't think it's created a new standard, and in fact, it may still be higher than you would see for termination cases on other grounds under certain statutes.
In the best interest of the child, would you ever look at, because you talked a lot about terminating parental rights completely, would you ever look at terminating legal custody, terminating physical custody, not allowing visitation, but still having an obligation to provide child support in the best interest of the child?
Yeah, so the child support issue is interesting. So one of the, I think it might have been Maryland, they proposed that this man, if she met her burden of clear and convincing evidence, he would still have to pay child support. I'm kind of on the fence about that, just because I think one thing is if a woman, and I know this sounds crazy to you, and it sounded crazy to me before I worked in domestic violence court, that a woman would lie about this, but they do. I mean, I have clients who I am pretty certain that this woman is completely lying about what this man did. And as a result, he is actually being put in jail. It's tragic. And so one of the things, it's kind of a disincentive for a woman to say, or to even bring the claim in the first place, if she knows she's going to lose child support. Now, it's not going to be a disincentive in every case, but it gives the case a little bit more legitimacy, I think. And then the other thing I struggle with, too, is if this man did rape this woman, I think funding is something we talked about. It's something I didn't really go that much into in my paper. Like, initially I was thinking maybe there needs to be something kind of set up in some other way, shape, or form. To keep getting money from this individual, I don't know, there's something, I feel like it maintains that connection. And what she needs is for that connection to be broken so that she can heal and move on. So, I mean, it's a very interesting issue, and some legislation I think is going to, it hasn't actually passed yet, but if it did, it would have allowed for it.
The other thing I would just say generally is that when you're looking at child support, the parental rights and responsibilities are a bundle of rights. So you have the right to have a relationship with the child. You have an obligation, a responsibility to support the child. So generally speaking, we don't take away the obligation to support, without also taking away the rights and responsibilities. We wouldn't keep the obligation to support without also keeping at least the possibility of those rights. And so you might cut it back by saying no visitation right now, but there's always a possibility of changing it in the future. And I think I worry about what happens in terms of the clients who might lie in order to get the guy out of the life but still get the money. But I also worry about setting precedent down the road for other situations where you would say, wait a minute, this is a whole package that's coming with as a parent, and we don't want to just sort of make it one-sided.
That's a good point.
Haley, you want anything?
Yeah, I actually had a very similar question to Candace, but I wonder in your answer if there is room or any states that allow for tort claims against a rapist father who causes a pregnancy, and then it's not child support, so it doesn't necessarily come with the parental right to a relationship, but because if the relationship were terminated, but if the mother might still be able to recover some of her costs from raising the child.
I mean, that's an interesting point. That's not something that I researched at all. I don't know.
I don't know the answer off the top of my head either.
Yeah. Yeah.
I was wondering, do you have any guidance in terms of where you go from here? Like, are you giving this proposal to any legislators? Is there anything that we can do with this issue?
That's a good question. I mean, I guess the first thing I'm doing is getting my note published and speaking here. Besides that, no, I'm not doing anything. But I think that I certainly think there is some place to go from here. I mean, I think legislators would be, there have been, like, for instance, there's a proposal right now in Pennsylvania. There's a proposal in Maryland that didn't get passed. I certainly think there's room for people to know about this. I think the problem is most people just simply don't, unless they're in the situation, they don't realize that this is an issue. I mean, I'm working at the public defender's office right now, and when I told them this, they were shocked. So I think there's a lot of room for people to learn about this. I don't have a set plan for that, though.
This is the first step, though.
Yeah.
Getting the note published is an important step.
Well, are we out of time?
We are just about out of time. You're welcome to, of course, come speak with Karen and Professor Bradley afterwards, but I would like to thank both of them for their
Produced by Duke University, online at duke.edu.